Okay, the next case is Martin Squire appellant versus Carlisle Township. And exactly noon, gentlemen, are we both ready to proceed?
I am, Your Honor. Yes.
You each will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes. Just please let me know when you're ready.
Good afternoon, Your Honors. May it please the Court. Attorney John J. Gill, bar number 0084118. I'm here on behalf of the appellants Martin Squire and Arlene Squire. This case centers around a long-term employment of Martin Squire at Carlisle Township. And he filed a complaint after he was terminated regarding raising several claims against the township. The court granted summary judgment, and I'd just like to go over the various claims and the reasons with you here today. So one of the claims raised by Martin was a promissory estoppel claim. The court decided that, well, one of the reasons the trial court decided that is the court determined that the employment of my client in the roads department was not a governmental function, and based on it not being a governmental function, he could not maintain a claim for promissory estoppel against the township. The citation to the revised code regarding that issue is 2744.01C2E, and the case cited by the appellees and used by the trial court deals with a negligence and conversion case by homeowners against a municipality. In this case, we would argue that the operation of a road department would not be a governmental function. And the reason, and the case law cited by the trial court and the appellees, they're using case law that deals with the administration of a system of public education. And there's case law that says that hiring and firing in the administration of a system of publication is a governmental function. Here, the specific statute that's cited by the appellees and used by the trial court deals with a provision of the Ohio Revised Code that addresses the regulation of roads. So it's a different, there's a distinction between a statute dealing with the regulation of roads versus a section of the statute dealing with the entire administration of a public education system. So I don't think that those two can, I don't think that the employment of my client falls under the category of a governmental function as a road employee. Secondly, on the promissory estoppel claim, the trial court determined and the appellees argued that there were no promises made. However, I think the evidence shows the exact opposite in this case. My client was told by the trustees of this township, which are the hiring and firing authority by their own testimony that's before the court in the depositions, that this was a temporary trial period for Mr. Squire. He was also giving an acting road superintendent designation as part of his promotion. There had never been in his 20 years an acting road superintendent position. So the logical conclusion based on that is consistent with my client's testimony and the evidence that this was a trial position for him, a temporary position. After about a year at that position, he asked to return to his prior position. After he asked to return to his prior position, he was then fired by Carlisle Township. So we feel that as it pertains to the promissory estoppel claim, we're not dealing with a governmental function, number one. And number two, there were evidence of promises. And whether the trial court didn't necessarily believe those promises, this was an issue that should have been submitted to the jury to determine whether there were promises or not. The second claim is the breach of an implied contract. And many of the arguments that go to the promissory estoppel overlap with the breach of an implied contract, but it boils down to direct statements from the hiring authority, his designation as the acting road superintendent, his history of employment for over 20 years at this agency, So many of those arguments overlap into the breach of implied contract, and we feel that there were statements that created an implied contract directly from the hiring authority. One of the other claims was a termination and violation of public policy, and the ruling of the trial court and the position of the appellees seems to take the position that because the specific parts of the Ohio Administrative Code that were referenced by the appellant's plaintiffs do not state by their own terms that it directly applies to a township, that this policy or the terms of those regulations can't apply to them. And our position is that this does create a public policy for protecting public employees from being arbitrarily terminated. This is a policy, and by our own admission, it doesn't directly say that it applies to municipalities or to townships. It is a regulation contained in the Ohio Administrative Code. So, but our position is that it does create a public policy. As far as the retaliation claim against the township, as noted earlier, Mr. Squire's position was not terminated until he actually requested to be returned to his prior position. And he requested to be returned to his prior position based on a belief that this was a trial, temporary trial position based on the representations made to him by the trustees, his history of employment there, his title as the acting road superintendent.
That's a good question. Would it have made any difference if the trustees said, you're not working out here, we don't want you to do this job anymore? Would they have had an obligation to put him back where he was, as opposed to him saying, I don't want to do this job anymore, put me back in my old job?
I think that he may have had an argument if he completed a valid probationary period that was represented to him. He may have an argument that there is a public policy that says that he shall be demoted to it. In this instance, I don't think that there was evidence to show that he wasn't doing a satisfactory job, or at least there's inconsistent evidence, but it would change things, I guess. But I do think he would still, if he could show that he completed a probationary period and that he was arbitrarily terminated, then he may have an argument for violation of that particular public policy. Moving to the loss of consortium claim, the trial court and the appellees argue that the injuries sustained by Martin Squire were strictly emotional injuries, and that a loss of consortium claim cannot be premised on strictly emotional injuries. And also, if his other claims are gone, obviously he wouldn't have a loss. There wouldn't be a loss of consortium claim as well. In this case, he did testify and he did present an affidavit of emotional injuries, but the affidavit and the testimony also contain physical manifestations of those injuries. So, in my perspective, that would be an issue. If there were physical manifestations of the injuries for Mr. Squire, that would be a determination by the jury to say whether these are purely emotional or purely physical injuries. And the information about the consortium claim is contained in Martin Squire's affidavit, paragraphs 75 and 76, and corroborated by the affidavit of Lorain Squire in paragraphs 12, 13, and 14. And finally, I would just note that there is a lot of reliance on the deposition testimony of Martin Squire and the decisions. If you review Exhibit 1 to his summary judgment, the affidavit of Martin Squire, he explicitly states that his deposition was only taken by the attorney for the defendant in this case, and that he submitted the affidavit in opposition to summary judgment to further explain his claims. So the affidavit that he submitted explains what was not explained at the deposition, because his deposition was taken by the defense, And many of the issues raised, in my opinion, were taken out of context. So if there's any questions, I'd be happy to answer them.
I don't believe so, but you have about 5 minutes left if you'll save that for rebuttal.
Yeah, I'll reserve.
Sounds
Thank
good.
you.
Thank you.
May it please the court, my name is Frank Saldone. I represent Carlisle Township. Here we have a case where the plaintiff is unquestionably an at-will employee. We have plaintiff's claims for promissory estoppel. Essentially, there's two primary claims, one for promissory estoppel and one for a public policy exception to at-will employment. I would disagree with opposing counsel with regard to a governmental function of operating a road department or hiring and firing decisions. It's obviously under well-established law and statute a governmental function. The Supreme Court of Ohio has expressly held that promissory estoppel claims cannot be raised against public entities, political subdivisions. So the trial court's reliance on that binding precedent is without error. Further, to establish promissory estoppel, there has to be an unequivocal promise. And here, the plaintiff himself, at his affidavit, paragraph 24, admits that no promise was made, admits that there was no employment agreement in his deposition at page 31. There simply was no official action by the trustees to enter into some sort of binding agreement that guarantees his continued employment.
Counsel, just by the name of the position of acting, in ordinary terms, people think of acting as somebody that takes the place and usually performs their same job, you know, instead of being hired as the actual person. So doesn't that give a little bit of indication that it's not a position that you're going to be fired from, so that you don't have a position, since you're only acting?
I know what you're saying, but I think if you read through the record, I mean, it's a probation. It was, he's appointed to be during a probationary period of a year to do this.
So why not just give him a probationary period and promote him to the role of superintendent?
I don't know. It's
Instead of calling him acting.
I don't know why they didn't do that. But the reality of it is it doesn't matter. I mean, he's an at-will employee that they can terminate for any reason. Just one that's not illegal. And the one claim that they started to raise was an age discrimination, and to their credit, they dismissed that. But it would be a situation such as that. If there was a wrongful reason, then there might be a prohibition on terminating. But he's an at-will employee. There's no promissory estoppel claim, and there's no public policy tort that I'm aware of that would apply to this.
So was he actually discharged, just like where you say whenever he wanted to return to his prior position?
He came to an executive session, when my reading of the record, came to an executive session and basically said, it really in no uncertain terms, but he basically said, this isn't a good fit for me. I don't want to do it anymore. And after that, there was a special meeting where he was terminated.
Was there a job for him to go back to?
Yeah, that's the thing. This is a small township, a small department of 3 people. There was not a position. There was not an opening. What he wanted them to do was to fire somebody they hired a year earlier, and the trustees apparently were unwilling to do that. So there wasn't an open position for him at the time.
Was there actual discussion that when he said, and obviously we'll read the record, but we don't have it at this point, was there an actual discussion when he came into the executive session and said, I just don't feel like this is a good fit for me and I need to go back to my other job? Did they actually say, well, if you want to do that, you'll be discharged?
I'm not sure of the finer detail of it. I think that is exactly what happened, and he said, fine, if that's what needs to happen, that'll do.
But that would be something in the record.
That'd be something in the record. But what I can say is there was at no time there was no representation to him that he would be continued to be employed, or that they would go out and fire the person that was there to make room for them in their small department.
Council, just a point of follow-up on those questions. It's my understanding that he comes to the public meeting and says, I don't want to continue in this. Then they go into executive session. Is that not correct? In other words, we don't have notes from the executive session.
No, I don't believe that those
In the
are
record.
in the record. I think there may be some testimony on that. That sounds, logically, that sounds more like what would happen. I don't think that he would be in executive session, but again, I'm not sure if the record reflects that completely. So you're right, logically, I think that's the way it would probably play out.
But
He
you're-
makes that statement in an open session, and then they go into executive session and make the determination.
Okay, but then the affidavits that happen subsequent talk about their reason for termination in the executive session. I know I'm getting far afield, but I'm a little bit concerned about talking about why he was fired when my thought is it's probably all happened in executive session and.
Oh, your concern is that they didn't make their ruling in an open session?
No. I'm just following up on questions regarding why he was fired and all this discourse about there was somebody already in his job.
Yeah, they had hired somebody a year earlier who's been doing the road for that period of time. But I guess that, if it's any consolation, it really doesn't matter because the township could terminate his employment at any time because he's an at-will employee.
It just seems weird that you wouldn't say, would accept your resignation.
Yeah,
Okay, and they
Yeah,
testified, that the trustees testified.
it just didn't play out in that manner, but effectively, it sounds like that's what his intent was, whether he wrote that, or whether they accepted it or not. That was the end result.
Thank you.
With regard, again, the at-will employment is based on an administrative code section. It does not apply to the townships. It only deals with state employees in classified civil service, and those are people with a property right. Here, the plaintiff has no property right, and there's really no legal right expressed to return to the position under these circumstances. It's not the type of clear public policy that would be articulated, and furthermore, it doesn't jeopardize the public policy, even if you could claim that there's a public policy there. It's related to people with a property right, not people who are township employees without that property right, not in classified civil service. So unless this court has any questions, we'll rest at this point and ask the court to affirm the trial court's decision.
Thank you.
Thank you, appreciate it.
Counsel, you have 5 minutes.
Thank you, Your Honors. I'd just like to briefly address the statutory issue of a governmental function. We don't dispute that a municipality has the ability to regulate or maintain its roads, but the actual creating the road department and then the hiring and firing of employees of the road department, falls outside the scope of that governmental function. And with respect to the 4 other jobs, or the other jobs available when Mr. Squire informed the trustees that he wanted to return to his previous position, that's addressed in paragraphs 35 and 36 of the affidavit attached to summary judgment, where that was exactly what Mr. Squire requested. He wanted to go back to his prior position. It was a road worker 3 position, and at that time there was no road worker 3 at Carlisle Township.
Had that position been terminated?
It just hadn't been refilled.
Was there some reason that was put on the record at a trustee meeting as to why that was never filled?
No, I did not obtain any reasons as to why they didn't have a road worker 3. I don't know that it was necessary that they had road worker 1, road worker 2, road worker 3 superintendent at the township, but for whatever reason, the testimony was that there was no road worker 3 at the time he requested to go back to that position. With respect to the public policy argument, again, the township argues that because these provisions of the Ohio Administrative Code don't explicitly say that they apply to townships, that they don't apply to, specifically to Carlisle Township. So to use the same analogy in a different area, you know, there's a general public policy for workplace safety in the state of Ohio. So if some safety, if there's this general policy, and because it doesn't, to follow their logic, if it doesn't explicitly state that it applies to the township, somehow they don't fall under that umbrella of having to abide by that public policy.
Well, counsel, did he articulate what public policy they were inspiring, his termination was in violation of? Is that, of course, is one of the elements of, I was unlawfully terminated in violation of public policy, is you have to articulate what public policy it is. Did he articulate what public policy Carlisle Township was violating?
In the brief in opposition to summary judgment, there was reference to several administrative regulations. If you're asking at the time that he requested to be demoted, or?
No, just as a legal matter, when he argues that he's terminated in violation of public policy, he needs to say what public policy he was terminated in violation of, does he not?
I would agree, Your Honor, and I would submit that there is information fully briefed in the brief in opposition to summary judgment that cites to several different public policies that he believes were violated.
But they're all administrative code provisions.
That's correct. Any further questions?
I don't believe so. All right.
Thank you.
Thank you. Thank you both, gentlemen, for your presentations to the court. The court will take the matter under advisement, issue a written opinion that will be sent to you, and also will release on our website. So thank you very much, and everybody have a great rest of the day. Square.